So welcome back, everyone, to the second panel. It is now, I believe, about 1:15. We have until 2:30 for this second panel with our esteemed speakers. So I think we are ready to go. We also have 15 minutes at the end for a Q&A, so you can start.
Great. Thank you all for being here. So I wanted to start off before we get going, recapping a little of the vision that we heard from the last panel, which really addressed the question of whether or not the Senate's advice and consent process is broken. And I think after listening to them, depressingly, we might have come to the conclusion that it's mired in partisanship, shedding more heat than light, often characterized by hypocritical assertions by senators about the way they're behaving versus or the way they are supposed to be behaving versus the way they actually behave, that it's going to get worse before it gets better, and that we're basically on a one-way ratchet downhill in terms of the process. It's also not particularly rigorous. Those were some of the things that I came away with from the panel. So before we get going, we're not going to spend too much time on asking the question whether or not the Senate's advice and consent role is broken. We're going to spend most of our time trying to talk about the consequences of the way we currently confirm judges. But before we get started on the larger topic, I want to ask the panelists to answer the question, do you agree with the first panel? Is the process broken? Are we on a one-way ratchet? And how would you characterize the way the process is broken?
Sure, thank you. And first I want to thank the Brennan Center and NYU for inviting me to participate. Yes, I do think the system is broken. I'm usually a glass half empty kind of person, and even I'm not willing to say it's a one-way ratchet because I do have sort of the long view that anything is fixable and reversible if we put our minds to it. And so I think, for me, you can't really look at what's happening with the court without looking at the larger context within which all this is happening. And I don't think it's overly political to say, or partisan to say, I'm not partisan, that we're sort of at an abnormal point in our nation's history regarding governance. And I think the danger of the process as it is right now is that, one of the dangers, I have many in my mind, is that the public will lose faith in the rule of law. They will see a system, a process, a vetting process where folks aren't properly vetted, folks are being considered and confirmed who are unqualified in almost any way you define it, some of them. And really is seen as it's almost like a political hackosphere confirmation process. And if people lose faith in the judges, lose faith in the political process, they'll lose faith in the rule of law. And quite frankly, that's the thread that holds the tapestry of our system together. So I think that's the danger, but I think it's fixable.
Great, yeah, no, I think it's broken beyond repair. Not much to say here. I think the breaking will lead to, and has already begun to lead to, a radical transformation of the federal courts, and I share the view that we're ultimately going to lead to a very dangerous place. But I do think that there are some important lessons to be learned, and while I don't think you can put the genie back in the bottle with respect to, blue slips are not going to come back in a meaningful way, but there are creative solutions, I think, that we can look for to actually move us forward. So I look forward to talking about those, but in terms of is it broken, the vacancy crisis that was created by I just want to lay some blame. It's broken, but we know who broke it. The vacancy crisis, the denying Merrick Garland a hearing at all, the stacking of the federal appellate judges on hearing panels, recess confirmation hearings, you name it, the scrapping of the blue slip, that's all on the Republicans, and it's broken.
Jamil?
Well, I think it's not broken from the perspective of a sitting president. From the perspective of a sitting president, Republican or Democrat, it's a very effective process. You nominate your candidates, they go to the Senate. If you have a majority in the Senate, your nominees get on the bench for your 4 or 8 years in office. And so it's a very productive process for appointing presidents who have a majority in the Senate, for appointing presidents who don't have a majority in the Senate, or for people who don't have the presidency or the Senate, it can be a frustrating situation. Of course, this is a situation that has been long in the making. It's a situation that came out of the decision to get rid of the filibuster for judicial nominees, and that has taken us to a place where we don't need consensus. And so even where the majority is close, as it was in the last sitting of the Senate with only 2 seats, it's widened now with 6. But when it's not close, you don't need to build bipartisan consensus because you don't have to get past cloture anymore. And so that's a challenge. And it's not surprising that you see a president post-cloture, as President Obama did in his time in office, being very aggressive about appointing as many nominees as possible to the courts of appeals, because that's where the win happens, or at least perceived. I think the larger problem that we see is, why are people so concerned about nominees to the federal bench? Why are people so concerned about appellate nominees? Why are people so concerned about Supreme Court nominees and who they are and what their politics are and what their judicial philosophy is? It's in part because the courts for a long time have not done their historical job. They are out there setting policy on a regular basis for the country rather than simply applying the law as written and applying the Constitution as written by our framers. They are implementing their own policy views, a lot of judges are, and increasingly they're motivated to do so by our political system. We as individuals and as lawyers, both Republican and Democrat alike, when we don't like what we get out of the political system, whether it's Congress or the president or both, we have become accustomed on both sides of the aisle to running to the courts and saying, you fix the problem, right? Rather than electing the people we want to elect, rather than holding our elected leaders accountable, we ask the courts to fix the policy problems we identify and then get upset when they don't, or if to the extent they do, we're very happy and we want more judges like that appointed. And that's exactly part of the problem. So the more that judges can get back to doing their jobs, the more we can hold legislatures accountable, the less we'll be worried about the process by which judges are nominated and confirmed, and to the extent that we can ever return to a process that has to come with putting back in place the cloture rule, and of course, nobody's in the majority wants to do that once it was gone, and that really is the perniciousness of having gotten rid of it in the first place.
Praveen.
Yeah, so I don't disagree with what Eric and Todd said about the whole process being broken, and perhaps irretrievably so. I think I don't want to say irretrievable yet, because there have been examples of things that have reversed. So, for instance, during the Bush administration, they cut the ABA out of the process. During the Obama administration, if it truly is a one-way ratchet, that we say, look, the ABA is an unnecessary extra layer that is just adding more time, sometimes vetting out candidates, because there was a productive conversation about whether it skews towards credentialing traditional law firm paths, minority and female candidates. But ultimately, the Obama administration decided we're going to include the ABA once again, bring them back into the process, and make them. So it hasn't entirely been a one-way ratchet. I think, though, to Eric's pessimism, I think that in this instance, it probably is. And I think the more productive conversation is what we do with the new normal rather than whether we can get it to the old normal. It's sort of like, how do we function both as a Senate in their advise and consent responsibility, but also as a voting public who now is going to have to vote for members based on how they voted on judges, which hasn't happened historically. And then the last thing about the confidence, I share Todd's concerns about the public's confidence in the court, which has always been higher than in the other more explicitly political branches of government. And so I will cite just 3 sets of data. Looking at Gallup polling, and this is percentage of respondents who have a, quote, a great deal or quite a lot of confidence in the institution. When you look at the Supreme Court, in 1988, 56% said they had a great deal or quite a lot of confidence in the institution. Compare that to 35% for Congress. So you see the spread there. In 1998, still 50% for the Supreme Court, 28% for Congress. So as the political dysfunction ratchets up, it's clear that the public has less confidence in institutions. Now move this to 2018, and this is before the Kavanaugh hearings, but 37%, we've dropped substantially, have confidence in the Supreme Court. and 11% for Congress. And I think we have only begun to imagine the effects that the Kavanaugh confirmation process will have on the long-term credibility and confidence in the court.
So let's put a pin in some of the initial discussions we had about potential solutions and about moving forward, and pivot for a brief period to the impact of this broken process on our judiciary and on our justice system. As I was thinking about it, I sort of thought there were a few buckets or categories of impacts, and they're not kind of perfectly discrete buckets. Sometimes they blend into each other. But as I thought about the buckets, I thought, well, one is the actual quality of the candidates who are being, brought through the nomination to the confirmation process, and that quality it has a blend of things. It's first, who are the people, the kind of the diversity of the candidates, combined with the actual qualifications or temperament or judicial philosophy of the candidates. The second big kind of impact bucket would be the perception of the legitimacy of the court. The third bucket would be the actual substance of the decisions. Is the judiciary as a whole moving in a particular angle or in a particular direction in terms of substance? And substance is huge, obviously. There are all sorts of subcategories of law. And then the final big bucket of impact that I was thinking about it, and I haven't quite figured out how to give a quick explanation for it, but is call it the separation of powers issues, the larger issue of our constitutional framework, the role of the Senate versus the role of the executive branch versus the role of the judiciary, and that larger sort of kind of structural question and how it impacts our democracy writ large. That's a pretty big bucket, and I'm not sure we're going to be able to spend too much time on it. But let's focus for a moment on the quality of the candidates. And so my first question is, President Trump thus far has had 84 nominees confirmed. I think there are another 50-odd pending in some level or another within the Senate at this stage of the game. Are they qualified? What percentage of these people would you say are qualified to be judges? Yeah.
So, there were, quite a few judges we've seen come through. I think, I would say, I don't have the stats in front of me, but at the time when, Brett Talley was coming through and some of the others, that Trump had nominated more, or at least the same number of not qualified judges by ABA's viewpoint in, I guess, 9 months, or his first 9 months that Bush had done his entire career or entire presidency. And that's, through the ABA lens, right? So that's temperament, that's sort of how you're going to be as a judge on the bench. For LDF, Racial Justice Organization, we also consider qualifications someone's qualification to be evaluated through the lens of how are you going to do with the rule of law? We're big fans of the rule of law, right? So we brought you Brown versus Board of Education. We've been discussing the rule of law and how our stakeholders should trust the rule of law, trust that the government will, and society as a whole, will bend that arc towards justice. So we look at our judicial nominations, look at the judicial nominees through the lens of what their record says about how they treat civil rights and racial justice. And by and large, the nominees, the more storied nominees that have come through this administration, have horrible records on civil and human rights. You have Tom Farr, who is pending, lower court judge, Eastern District of North Carolina, who was sort of the go-to person for voter suppression, sat at the feet of Jesse Helms. And the scare there is that that'll become sort of the measure of horribleness. But we have others, right? We have a judge who actually went through, Norris, who was a Tennessee legislator, who supported anti-LGBT legislation, resegregation legislation. And in the past, you would have, I think, judicial nominees who may not have a paper record or may do something to try to mask their record on the way up. But it seems that it's almost like these are qualifications that this administration is sort of looking for. And I feel that in some ways it's designed to sort of integrate the judiciary into the governance strategy for this administration, who, by the way, has policies that are sort of anti-civil rights and anti-human rights. And it's their way of sort of locking in those retrograde policies. So in terms of qualifications, we look at how judge would be with regard to those rule of law issues. And since we had at least 4 judges who refused to, actually 4 plus and counting, who refused to endorse Brown versus Board of Education, it should give you a lot of pause as to how qualified these folks are writ large.
So, Jamil, let me ask you a quick question, kind of following up on that, or varying the question to a slight degree. If we think the system is broken, if we think the role of the Senate to a certain degree is to serve as a kind of a quality control process on presidential nominees, do we conclude then that the quality of judges who've been confirmed under this broken process, which hasn't just been broken under the Trump presidency, but do we conclude that many of these judges who have been appointed are not qualified, are low quality, are not the quality we would want?
No, I don't think so. I don't think the process speaks to their quality. I think the nominees themselves speak to the quality. And if you look at the very metric that we just talked about, the ABA's qualification ratings, the vast majority of the Trump nominees, as was the case in the Bush administration, as was the case in the Obama administration, as was the case in the Clinton administration, were either well qualified or unanimously well qualified. So this idea somehow that the quality has dramatically dropped off under Donald Trump, and I'm not a particular Donald Trump fan. I was an early adopter of the anti-Trump movement, signed the March 2016 letter, right? That being said, I mean, the idea that Donald Trump's judicial nominees have been unqualified or are not well qualified is ridiculous, even on the ABA's own basis. And so sort of this sort of smear that the Trump administration is nominating a huge set of unqualified nominees, or frankly, I think what was put on the table was racist nominees, I think is outrageous and is patently false. And the record doesn't support that. So, I mean, let's be candid about the vast majority of these nominees. You can point at 1 or 2 you might have concerns with. You can point at, and there were some famous flameouts. I think we saw during the confirmation hearings. By the way, I would note under questioning by Republican senators, these flameouts happened. But this idea that somehow there's a vast lack of qualification on these nominees is just patently false.
Can I jump in?
Yes, please.
So I think that depends on whether you think die-hard ideology makes someone not qualified to
You mean like Lucy Coe or Goodwin Liu?
I'll go through my tickler here. I spent the last few years at Lambda Legal going through everybody's record, looking at these judicial nominees, not only for how extreme their views are, which I'll address, but also to your point about the process didn't lead us here. The process absolutely led us here because we have outsourced the picking to the Federalist Society, to the Judicial Crisis Network, and the Heritage Foundation, and these groups are reaching into the Alliance Defending Freedom, an anti-LGBT hate group, reaching into the Beckett Fund and pulling up these lawyers to populate the federal bench. And because we don't have a meaningful check on these ideological persuasions, they're all sailing through. And let me give you just a slice of some of the really disgusting anti-LGBT folks we've seen. Stuart Kyle Duncan, who was defending HB2 in North Carolina, the anti-trans legislation. Jeff Mateer, who famously, at least we were able to stop this one, famously said that trans students are part of Satan's plan for the destruction of society. Let's see, Damian Schiff, who wrote about how California is trying to teach gayness in our schools. I could go on and on. Stephen Grotz, who was the president of an organization that actively promotes conversion therapy, rated not qualified by the ABA, so them too also saying, hey, your peers think you're bad. All of these folks, some of them got stopped, but some of these folks are now appellate judges. And yes, the process contributed to this. There is no meaningful check. And the idea that somebody like Senator Collins is going to stand up and say, hey, this is a little too scary even for me, when you've got the Judicial Crisis Network coming at you with a $10 million ad buy, is ludicrous.
Well, so
Wait,
let's
Praveen,
talk about that. Let's talk about that.
Praveen, let's let Praveen have a quick word, and then we'll talk about it.
So I think that there's something a little bit curious going on here in that there's an asymmetry about the use of the ABA system. So the ABA is either a useful or not useful system, right? So you cannot simultaneously cut them out of the system and say we're not going to wait till Senate Judiciary Committee hearings until the ABA ratings are out, but then also use the ABA ratings to buttress your nominees.
Why
Like
not?
it just
Why not? Hold on. Why can't you simply say we don't think they're a useful tool, but when they rate our candidates, if they rate them well, we're happy to cite it. That happens all the time. Happens all the time. There's nothing like by definition wrong with that.
but if the
I mean, you
ratings,
can't fight the point that the ABA the vast majority are well qualified, unanimously well qualified, right? Let's talk on the stats.
yeah, I'm just saying that I don't disagree with you on the number of the stats, but my point is, if it is a useful tool, and in some sense the fact that they were rated qualified is meaningful, then it is an endorsement in some sense of the ABA system. You've yourself.
I don't think so. I'm simply using the statistics that were cited back. Right. The question was, how do you measure qualifications? If you want to say the ABA system is a good measure, right, which I think is the point that was made, it's a good measure. Okay. Well, on that basis, these nominees are well qualified. I'm not saying I would use that system.
Is it
but
the
use this
only
system
measure?
that was.
Is it the
So
only
I would
measure?
say, and I definitely don't think that. Like, I think that the ABA looks at a very, very constrained set of things, right? They don't get into ideology. They don't get into those kinds of things. They look at a set of qualifications, threshold qualifications about temperament, but also your background, the trial experience, those sorts of things. I think it is a useful measure. I certainly don't think it is the end of a conversation. So I think Jamil and I probably have an agreement about that. It is a threshold determination, like a driver's license would be. The fact that you can drive a car doesn't necessarily mean that I want you to drive a bus. And so I think the ABA to me is a useful determination of some baseline threshold qualifications. I don't know that it's the end of a conversation, but I do think that you have a useful role in the process. And I think you do see, and I'm not talking about Jamil, but I do see both Republicans saying that the system is not useful, but then also people using that same system to buttress candidates. So I pause there, but I would say that I think that the conversation about substance has sort of trickled into everyone's comments, Todd's, et cetera. It's more than just, and it certainly,
That's right.
it certainly wasn't part of the first panel. It's more than just where you went to school, the number of years you've had on the bench. We do get to substantive issues, and even Jamil talked about judges that follow the law, right, and don't make policy. This is about substantive outcomes in your cases, and so I think in some sense we're all agreeing on that there is something a little bit more than just years on the bench, trial experience, and your grades in law school and where you went to school.
Right, because one of the difficult questions about understanding the Senate's role in its advice and consent role is having an understanding of what the Senate regards as qualified and what factors it can or should look at in determining quality or qualifications of someone. Is it merely you passed law school, you've passed the bar, you've been 10 years in practice, you don't seem to have committed any crimes, therefore you are general, and you've got good temperament and good judgment, therefore you are qualified, or is it broader than that? And I think one of the things that the first panel was talking about and struggling with was this question of when trying to understand what the Senate's advice and consent role is how broad is their scope of advice? How broad is it? And I think that one of the things that the panel concluded is that the Senate's advice and consent role is, and their vision of their role is very restricted right now. It is mired in partisanship. It's rubber stampy as long as the nominee came from the president of the same party, and that can obviously occur regardless of who it is. And so that's a little bit of the point behind my question. I don't know.
So, no, I mean, I think
Yeah.
from our perspective, obviously, the advice and consent rule is broad, right? It's not just going through a resume and selecting judges. The problem we have now, and I think the Kavanaugh confirmation process is sort of a case study. The problem we have now is that, we have a process where the Senate the Senate Judiciary Committee is not being given an opportunity to actually truly vet the nominees. We have hearings being held during recess. We have, as someone mentioned before, judges being stacked, judges being put with other executive branch nominees so that you can't really have a lot of time to actually vet folks. You have a situation where, again, in the Kavanaugh context, where they withheld documents or characterized documents as confidential when they truly weren't. I think, and then also there's the consultation piece, right? So there's a lot of facets or elements of the advice and consent role that get to, I think, allowing the Senate to truly evaluate someone's qualifications. So yes, an ABA score, that's easy. No, you don't need too much to really evaluate that. But to truly understand how a person thinks, to understand what someone's philosophy is going to be, to see what someone's ideology is, then look at their cases and say, well, you're flipped for a certain outcome. That involves some rigor, and it involves some inquiry. And if you don't have the documents, if you don't have the time to actually have that inquiry, if perhaps the president and his party are afraid to have you delve into it, then you don't have a true process. And again, I go back to confidence. The people start seeing the judiciary as just an element, or just an extension of the larger, executive branch, judiciary branch. And then what do we have?
Yes, so Jamil, you're, I think, the only person on this panel who has worked in the executive branch in the process of picking judges. Is that, have I got that right? If anyone else on the panel was, let me know. I looked at. So when you were in that behind the scenes role of helping pick nominees, were you afraid of what the Senate might do when it kind of conducted its advice and consent role? Did you?
No, I think
Yeah.
we welcomed it, and I think that the same is true today. I don't think there's any question that people are afraid of the Senate's role. The Senate should have a robust role. It's our constitutional process. They're expected to provide their advice and consent, and they should do that. When we looked at nominees in the Bush administration, we spent a lot of time before somebody was nominated diving deep on them, and we would look at all of their cases. We'd write up a memo. We'd call every judge in the district in which they were nominated, in the Court of Appeals in which they were nominated, to ask about their own, about the judge's view of that litigator or that lawyer. We would call their colleagues at their law firm. We'd call the opposing counsel in their cases. We would sit there and vet these people at a very detailed level. We'd look through their background report. We'd put all this information into a memo. This is before somebody's even considered by the White House for nomination. This is somebody who's just being a potential candidate. That information would then go through the Justice Department and go to the White House counsel's office. They would vet it, and ultimately would go to the president for decision. And so there was a long, drawn-out process before somebody would be announced publicly as a nominee. And so that process made us confident that there would not be challenges in the Senate, because we'd already done all of our homework on these people and prepared for any potential challenges. And to the extent there were concerns, those were well understood, had been well thought through, and we were prepared to defend those nominees before the Senate. Now, given that there are clearly some nominees who face some challenges in this administration, whether fairly or not, one might ask whether that process is working effectively, and that's a fair question, right? But let's be honest, the fact that we know that some of these nominees have had challenges is proof that, in fact, the Senate is doing its job. The Senate has the time and the ability and the capability to identify nominees that thinks are not qualified or are problematic and stop them. And individual senators have, in fact, stopped them. This idea that Susan Collins can't stand up to JCN, but she has. And the reality is that time and time again, an individual senator, right, can stand and say, no, I actually don't want this nominee to go through. And when there are only 2 votes separating a nominee from confirmation, even in a post filibuster's gone world, right, those senators have a lot of ability. Now, the facts also on the ground are that in this past midterm election, right, the president's party has gained seats in the Senate. That suggests that, in fact, at least on a state-by-state basis, the American people don't think the process is broken in the U.S. Senate, and the process is working effectively. Otherwise, they would have voted for the opposition, right? And they would have voted for the opposition in those states and would have gained majorities. So the fact that the president has more seats now, right, suggests in fact that the American people aren't as upset as the people on this panel are about the outcomes of this current confirmation process.
Or it suggests that they vote on a lot of things other than just judicial confirmations.
Sure, like the that's right, like tax policy, like the economy,
And that
right?
they only vote for a
And-
third of the Senate seats at a time, and that the way the seats are distributed geographically makes a difference in terms of their impact, and so on and so forth, and that the majority of the American population in any event did vote for a change in party control, or voted against the president's party, but.
Again, I'm not
but-
saying this is somebody who supports the president's policies. What I'm saying to you is that if the situation were as dire as it sounds, having heard the last 15 minutes or 30 minutes or last 2 hours of conversation, right, we might have seen different outcomes.
Let me just say, I'm sorry. Let me just say, this notion. I've had actually people say this to me also, that, if the American people wanted a change in the Supreme Court, they would have changed the majority in the Senate. If my life were based on a majoritarian view of the world, I wouldn't be sitting here. The job of the Supreme Court, therefore the job of the Senate, is to ensure we have quality judges that aren't necessarily at the whim of the majority, at the whim of any particular, hysterical anger of a particular president. It's more rigorous than that, requires more rigor. One thing you didn't mention, which I know you did, was you consulted with the Senate before you made the nomination, most likely, across party lines. That's not happening anymore. That's not happening anymore because this administration sees the judicial nomination process as an extension of its policy machine. Now, whether or not, and as you mentioned, it's his choice, the president can do that, the long-term damage of that, the long-term damage of me not being able to look a client or a constituent in the eye and say, believe in the rule of law, is something that I don't think we want to really explore too deeply. So I think the reason why I'm saying this can be fixed is because it has to be fixed.
I agree with that.
If we lose faith in the rule of law and in the Supreme Court, it's on.
I agree 100%.
And let me
the-
finish.
yeah.
I think that organizations like Legal Defense Fund, organizations like AFJ, others in this panel, were the ones that vetted and outed Brett Talley and others, not the Senate, certainly not the Republicans on the Senate. So the fact that Scott stood up and said Ryan Bounds can't go forward wasn't because Senator Grassley went to him and said this person's no good. It was because organizations like AFJ, Leadership Conference, LDF, and others stood up and let him know that was the case. So I don't want there to be any delusion about what this process is yielding. We're part of that process, absolutely. But those who are actually charged and elected and paid to run this process are not doing it in a way that is fair and equitable. And at some point, voters are going to find out, and they're going to recognize that it's not working.
So Praveen gave us some numbers on people's faith in the judiciary and its decline. And that was, as you pointed out, pre-Kavanaugh hearings. We've kind of had a brief discussion about quality of candidates and quality of the judiciary. Eric, do you agree that the broken process is affecting the Americans' perception of the legitimacy of the court, maybe even its actual legitimacy?
Yes. And just to piggyback off what's been said, I'm deeply concerned about the way that this process is playing out and the ideological bent that we're moving in. If we get another the judiciary is going to become more ideologically driven. I don't think I could look at a client who is going before some of those folks that I just listed, who's fighting to make sure that gender identity is recognized under Title VII, or that a sexual orientation the same way, or that places of public accommodation are going to be open to everyone, and say, you're going to get a fair shake in this court. In most circuits, if this continues, I would be like, don't bring this case in federal court now. Now, a lot of the organizations that I described, Alliance Defending Freedom, Beckett Fund, are cherry picking these cases on their own terms and bringing them up, so they get really bad rulings for us. But there's no question that we're getting farther and farther away from fair and impartial courts, and that's a problem for legitimacy. I think we're running a real risk, and I think Kavanaugh exemplified this very well. Not only does the public not trust the process and what just happened, with the total betrayal and setting aside of Christine Blasey Ford and everything that she spoke about and stood for, but for Kavanaugh to sit up there and make a partisan, go on a partisan diatribe about like, you'll see you're gonna get payback for this, you and the Clintons who came after me. The point is that a person who said that in a confirmation hearing now sits on the highest court in the land. That is the new reality. So yes, it's more ideologically driven. I think there are possible benefits to this, meaning that, or ways that we can balance this out. I think once you have a Democratic president and a Democratic Senate, we can finally get some civil and human rights folks confirmed, defense attorneys who are not confirmed to the federal bench confirmed, and we can start to roll back once again the disastrous diversity record that this court or this administration has had, where you are seeing just 10% people of color, 28% women. That's astounding. You lose faith in you lose confidence in the courts, not only when they don't value the constitutional beliefs that most people share, but also when they don't look anything like the people that they serve. And that's the reality that we're going to deal with. We're dealing with it already, and it's getting enormously worse.
So, Eric, let me just poke a little bit at what you just said, which is that, you know, in this, when there's a Democratic president and a Democratic Senate, and judges are appointed who are more friendly to some of the issues that you believe in, why don't you think that that wouldn't provoke a legitimacy crisis amongst a different set of people?
My personal view is of who the Constitution protects and what judges are there to do. And some people have described balls and strikes. I look at it very differently. Discrete and insular minorities, folks who depend on counter-majoritarian forces that the courts are supposed to serve for people who are marginalized, who don't get the majority of votes, who need protection from the courts, because voting majorities, frankly, aren't going to protect their rights. And if you come from the Constitution from that perspective, it makes total sense that you would want people who have those values on the courts. But the point is, whether you come at that's going to be a disagreement between like us on philosophy, that's fine. But when you have one side that's drastically ideological and the other side, even Obama, we're appointing pretty middle of the road corporate attorneys. The process has got to change. We've either got to, unfortunately, swing way to the other end, or get back to the center. And I don't know how you do that.
Praveen, you look like you want to get in. Maybe not. Jamil.
I mean, this idea that it's only fair and impartial when they decide Eric's way, right? Then the judges are fair and impartial. When they implement Eric's sort of vision of what the law should be and what courts should do, and that it's counter-majoritarian. I think there is certainly truth in what you're saying, that the idea of the courts as a counter-majoritarian institution as a general matter is absolutely true. Right? The idea is that the courts are there to enforce the Constitution as against laws passed by Congress, right? To the extent that you believe Marbury was correct, as we all do, right? That the role of the courts is to say what the law is, not what it should be, and what the Constitution is, even when Congress has done something different. They are a counter-majoritarian institution in that sense. But you can't say fair and impartial on one hand and middle of the road on one hand when you know that just as President Trump and President Bush appointed judges of their ideology and a certain view and judicial philosophy, right? President Obama did the same thing. It's not fair and impartial when it's your guys, and not fair and impartial when it's the other guy's guys. That's not fair and impartial. So let's just call it what it is. It's okay if we're ideological and we want people of our own ideologies, our own judicial philosophy or whatever. That's okay. That's a perfectly acceptable place to be. I do think, that you're right to say also that the role of the Senate is to carefully vet these people, and the role of the Senate is to provide a check on the decisions of a popularly elected president or a president elected through the Electoral College or whatever you want to say, right? The way the president is elected. That is absolutely true. But how did we get here? How do we get to a place where courts of appeals judges are confirmed by a simple majority of the Senate? It's very easy to look back and figure out why. Because during the Obama administration, Democrats in control of the Senate voted to get rid of a 180-year-old institution, the filibuster.
Actually,
Well, less than 180 years, that's true. It's changed over
1970.
time. It's changed over time, that's true, right? But a long-standing, at least, decades-long, maybe even almost a century-long, right, tradition, particularly when it comes to nominees, right? And yes, the Republicans in control of the Senate under a Republican president apply that same theory of the world to Supreme Court nominees, right? But that's why you don't need balance. It's why today, without a substantial majority in the Senate, without a more than 10 vote majority in the Senate, right, you don't need to find consensus because we threw away the filibuster. Now, should we put it back in place? Absolutely. Would that make for better outcomes on both sides? Absolutely. Would it make our judiciary less quote unquote ideological or less of one partisan philosophy? Yes. But there is no senator in the United States Senate right now, say maybe a couple, who are arguing for if we come back into the majority, or if we have the majority now, we should reinstitute the filibuster. I'm not hearing that. I have not heard one Democratic senator say, if we are back in the majority, including the majority leader, I will reinstitute the filibuster for judicial nominees. I hear that, then let's have a debate about why ideology is so problematic.
Todd, you've got some views on
So
the.
I don't think,
yeah.
I'm sorry, I don't think ideology is problematic per se. I think not wanting to adhere to the rule of law is problematic. So you have Justice Alito, Justice Roberts, no one's non-ideological justice, right? And we were talking about judges, calling balls and strikes. We're talking about judges who are fair and impartial. I'm thinking about Shelby, where a judge just disregarded what the Congress said and decided for himself that he thought voting rights were no longer a thing. So we obviously have judges who are ideological and making all kinds of rulings based not necessarily on the Constitution, but based on all kinds of other biases. The good news before this administration was and this Senate was that a lot of that was filtered through something called norms, something called sort of checks and balances that allowed others to have some input. You had Alito, Roberts, all of them endorsed Brown, thought Brown was the bee's knees. You have now judges being kind of cute with it, saying, the canons won't allow me to comment on Brown. Would we tolerate that if they said that about Marbury versus Madison? Would we tolerate a physicist saying, I'm a little equivocal on whether the earth is round or flat? No. There are certain standards that we've just lost with this administration. And my concern, my trouble is that beyond the Senate, we haven't done a very good job educating the public about what that means. What that means is that we can have a process, as was alluded to here, where we have a judge lose all credibility and really demonstrate that he has no judicial temperament through partisan tirades, and have that be okay. We have a situation where the Senate can baldly withhold documents that the Senate needs to fully vet a nominee, and that is considered okay. I think that this loss of norms is what's really at the problem here. It's really at stake. What's at stake, and again, I go back to what's the fear? You have the numbers, you have majority. What's the concern with having some consultation with Senator Booker before you appoint someone to the Third Circuit? What's the problem with that? What's the problem with consulting with Sherrod Brown before you appoint someone to the Sixth Circuit? What's the hurry? So I think there's a lot to unearth regarding what's really going on here when we talk about removing norms, removing this consultation, removing the collegiality that really resulted in an Alito and a Roberts being able to ascend to the Supreme Court despite their ideology. That's the legitimacy problem. That's the legitimacy gap. Ideology is one thing. Legitimacy is quite another. And the court and the Senate is losing or has lost legitimacy.
So we've only got a few minutes before we're going to open it up to the audience, but I want to kind of pivot real quickly to some of the solutions questions, and let's go back to this. Let's go specifically to the issue of the New Jersey senators not being consulted on the appeals court nominees that I think there was just a hearing on this week, right? Can you imagine a world in which Cory Booker is the chairman of the Judiciary Committee and a future president appoints someone to a circuit court seat where the Republican is in charge, and Cory Booker would reinstate the blue slip for that senator? Would that happen?
Let me go, I
Yeah.
want to answer that question, but let me go back to my fantasy, right? My fantasy is that we do a good enough job educating the public so that a Cory Booker would be afraid not to do that. Okay? what we have here is the beginnings of the public starting to be aware of not only the importance of judges and what's at stake, but how truly, be colloquial, messed up this process is. So my hope, my goal, is that Cory Booker would think twice before he removed the blue slip. The problem is Grassley didn't think twice. Grassley, responding to his stakeholders, said, I'm absolutely doing that because I want to absolutely push these people through. McConnell, I want to absolutely push these people through. I want there to be a moment of pause before anyone does that in the future because voters are going to hold them accountable for it. Moreover, because our profession as lawyers are going to hold people accountable for it. Our profession needs to step up and start being basically the arbiters, the protectors of the rule of law and of the process that's actually that's sort of running amok now. So the answer to your question is, I hope so. I hope he would give pause, but I wouldn't necessarily, as much as I respect Senator Booker, wouldn't want to trust that. I'd want to make sure that there are some accountability measures in place, the same accountability measures we put in place in other parts of the Congress and other parts of the government.
So, but before kind of asking people to speak more generally about this, let me just ask a quick question to everyone on the panel, yes or no. If without querying whether or not it can be done, do
Yeah.
you think we should restore the full blue slip process?
Me first?
Yeah.
I mean, I think, yeah, I mean, or just this idea of not consulting with, not being collegial, I think is troubling. And to me, it goes beyond the blue slip. It goes to the White House saying, you know what, I'm going to reach out and talk to the home state senator before I do this. May or may not matter regarding his decision. I'm sure Bush did it. What's the concern? What's the fear for doing that? So yes, I think we should have some consultation.
No, but what I do think might be a creative solution, relying on some of the Brennan Center's research, is looking to state courts and how they do it. So I could see a Democratic president going to a Republican senator in the Fifth Circuit and saying, look, you don't have a blue slip, you can't block the nominee I'm going to make, but I'd like to nominate somebody based on, if you set up a nominating commission, if you vet some people, I will take your home state views into account. If this nominating commission is diverse and made up of a good representation of the state, I will consider a name that you put forward instead of somebody that I throw out there. Now a Democrat has some leverage to be able to do that. I think it would improve the process, give some home state senators of a different party some stake in the game to put forward the most qualified nominee that they could, and one that is a little bit more in line with the ideology of the president. I think that would be a creative and, restore a little bit of faith from the home state into the process of the way that their judges are selected.
Camille?
So I think the idea that there's not consultations happening is just not accurate. I mean, if you go back and look, the Senate Judiciary Committee recently released the letters back and forth with the California senators about the nominees to the Ninth Circuit. What's clear from that record is that there were dozens and dozens of conversations and dozens of attempts to try and find a path forward. Historically, circuit court nominees have not generally been subjected to a rigorous blue slip process. It's been more, on occasion. District court nominees certainly, but appellate nominees certainly not. And if you look back, absolutely not. You can look skeptically, but if you look...
I worked
if you
on
look,
the Senate Judiciary Committee
Yep.
for 8 years
If you-
and put in a lot of blue slips and ran a nominating commission
and-
with Democratic senators against President Bush, and our blue slip was absolutely...
And deals were cut to address that system and to get past them. But by and large, the blue slip process was on its way to collapse, right? Because frankly, the blue slip process had been abused by senators against administrations in both parties, right? And so the process was weakened as it was, right? And I think what gave it the death knell, honestly, in a lot of ways, is the decision to get rid of the filibuster. Because the reason why this norm, right, of blue slip, and I agree with Todd that norms are important, but norms are enforced through rules at times, right? I mean, norms are the baseline that allow us to create rules that are enforceable, and one reinforce the other. Rules reinforce norms, and vice versa.
Yeah.
And
The blue slip was essentially a foreshortened or foreshadowed filibuster.
That's right, exactly right. And
Right.
so that's exactly right. And so it was respected sort of in that sense. And without the filibuster, the process made no sense anyhow, and it was already been weakened. And so at the end of the day, I think that one thing you have to consider, and I would love to see Senator Schumer come out and say it, that if he were the majority leader, he would restore the filibuster, right? I dare Senator Schumer to come out and say that. He
What
won't.
if he does?
He won't.
What if he does? What are you going to do if he does?
Well, then we'll see if he does when he gets into power. I was an advocate when we took the Senate back that we should restore the filibuster.
Okay.
That they didn't ultimately do that.
So it sounds like you're no on blue slip restoration, though. Is that?
Well, I don't really think it matters because all that matters is it's unenforceable unless you have the filibuster. Without the filibuster, it doesn't matter. The blue slip process is sort of irrelevant. I do think where the value is though is ensuring that you include the senators in the process. The senators have to be willing to play ball. They have to be willing to make deals. And the reality is that today, for whatever reason, ideology or the desire to sort of resist, and I understand the desire to resist. It's not that it's not without reason. But it's resulted in a place where senators aren't willing to make any deals. And when that happens, the president has no choice but to roll senators if they're not going to make deals.
Praveen, blue slip back in or out?
So, I think there are values to the blue slip process. I think the value is only there, though, if it is truly respected by everybody. I think the asymmetries, whatever you say about the rule, and you can defend it or not defend it, I think the most dangerous scenario is where you have these asymmetries. And I was interested in the first panel about the discussion about the asymmetrical sort of respect of certain things or asymmetrical excitement from voters on judges, et cetera. I think that's where you have these problems. And so I would be fine with the blue slip coming back, but only if I could ensure that it was symmetrically observed. And I think that, unfortunately, because it's a norm and not a rule, you can't do that. I think that the value of the blue slip had been that home state senators are most likely to have the inside knowledge from local bar associations, specialty bar associations, the sort of, who is good, who plays well with others, who could sort of be a collegial force on the bench. So I think that the blue slip process served a purpose. As you know, since you were on the Senate Judiciary Committee, it was also abused at times. And Senator Leahy got to a place where he said, I'm not going to allow a secret hold. If you're not going to return your blue slip, I do want you to articulate why that is, which had not always been the case. If you just didn't return your blue slip, you didn't have to articulate why that was. You could just, hold someone by doing that. And so, I don't really care either way. I think if we bring it back, it has to be symmetrically observed because unilateral disarmament doesn't work for any party.
So let's quickly talk about, that was one particular solution that I wanted to kind of prompt people to talk about, and we've had already a discussion about the filibuster. Are there other things that you guys think of as potential solutions to help, kind of restore a sense of legitimacy in the Senate's role and ultimately to restore a greater sense of public confidence in our judicial confirmation process and the judiciary itself? Eric, why don't we start with you? Do you mind?
Yeah, no. Overturn Citizens United.
Okay.
I think one of the biggest problems that we're getting ready to face and that we're already facing from looking at state courts is judicial crisis networks and groups like that dump money into races. They've been playing in the state Supreme Court space very, very effectively. Now they're playing in the federal courts very, very effectively. And I think the problem that you're going to have is, and we've seen in the state court space, is that spending influences the decisions that judges make. There's empirical data that shows that you issue more pro-corporate decisions, you uphold the death penalty more often, you send more people to jail, the more money that's spent against you in your race. So what I see at the federal level is when this money pours in, it promotes folks who go, if I don't adhere to these ideological constraints, what my party, what the Judicial Crisis Network values, what the Federalist Society values, I'm not going to move up the ranks of either the state court system or the federal court system. And what that means is you start to get ideological decisions. I doubt that if Judge Sutton had it to do over again, he would have ruled that way in the ACA case, now knowing that it's going to prevent him from ever serving on the Supreme Court. So I do think that's going to have a really long-term disastrous effect is the outside influence of outside groups that are going to dominate this process now.
Okay, I know that everyone else has actually got a fair amount of opinions, but do we need to wrap, or is there time for audience questions? We have time for audience questions too? Okay, good. So just if I can ask everyone to you know, to give your point real quickly so that the audience does have a chance to ask some questions. So Jamil?
Well, I just think there's an interesting tension between Todd's perspective, which I think is right, that a lot of the ideological groups have an important role to play in identifying challenges with candidates and saying, I don't think this candidate is qualified. Here are the reasons why I don't think this candidate is capable or correct. And with what Eric's saying, which is these ideological groups are playing too aggressive a role and playing too much of a role. I think there's a tension there, right, between informing voters and informing elected officials about these individuals. I think the best case for Eric's position, I think, is a good example of why judges should not be elected. It's a good example of why judges should be nominated by an executive official and should be subject to confirmation through the political process, because judges who are elected are influenced by ideology, because that's what elections are about. It's why in the federal system we decide not to elect judges and provide them life tenure and protect their salaries so they would not be ideological or motivated at least by electoral ideology. They might have judicial philosophy, but they don't have electoral ideology in the ideal world, right? And so I think Eric is right to say that we want to avoid that type of a process, but when you have a process where there's nomination and confirmation, I think that Todd is also right, which is that there is value in groups with perspectives, expressing their perspectives about these nominees and telling voters and people who are voting for senators or representatives in the case of some state house systems who are confirming these individuals. I think there's value in that too, and I think there is some tension between communicating information to the public about these nominees.
It's a paradox. Praveen?
So I think educating the public on nominees, but in a way that's digestible, is important. I think Todd said it really well. Regardless of whether you trust someone who's in charge of a Senate Judiciary Committee, their feet are either held to the fire or not by the public that elects them. And so, you know, I think that providing a landscape where people can understand more about nominees is important. I mean, Jamil had said that the elections might have been a vindication of where we were on judges, but that presumes that people are voting on judges, and one, that tends to not be true, and to the extent that it is true, it's asymmetrical. I will say that during the last presidential campaign, candidate Clinton mentioned Merrick Garland early on in the campaign and then puttered out. Contrast that to President Trump, now President Trump, then candidate Trump, who was talking about Roe v. Wade all the time and his ability to fill the court. And so there was clearly a calculation there that a set of conservative voters were more energized by the courts. And we had a nominee that never had a hearing. So, you know, that could have just as well been a situs and locus of rage on the left, but the decision had been that doesn't fire up voters. But I think that people don't understand how to evaluate a judicial nominee. It's difficult. What does it mean when you wrote an opinion? What does it mean when you joined an opinion? Like if you're on one side of the case, but you're a panel of like 4 judges in an en banc hearing, what does that mean if you didn't author the case? What does it mean if you wrote a separate dissent and it's your own voice? I think these are hard things to manage, and I think that honestly, groups that serve as proxies for people who care about issues should start scoring votes on judicial nominees. So for instance, if you're an environmental person who environmental values motivate your voting decisions, you look at something like the League of Conservation Voters Congressional Scorecard. Who knows congressional scorecards here? Right, it's where an organization looks at votes that your members take, and they decide to score certain votes, and your overall like candidate score goes up or down based on whether you voted on certain ways. But for the most part, progressive groups have not historically scored judicial nominees. So LCV has had a scorecard for 10 years.
Why is that?
Honestly, I think they have not wanted to play in a space of politicizing judicial decisions. That's my guess, but I don't know. But LCV this year, for the first time, started scoring votes on judicial nominees. And so it's had a very powerful environmental scorecard for over 10 years. But in this Congress, I shouldn't say this year, in this Congress, was the first time they started scoring judges. And so I think if you're an environmental voter, that's a proxy for you. And then you can vote for your senators, yay or nay, based in part on that.
Can we just ask, do we know why other groups don't? I'm just interested to know, do we know why other groups don't score?
I don't know.
Yeah.
I know in a case for a few groups,
Yeah.
but yeah.
A few do.
Yeah, no, I know in
Oh.
a few cases why they don't, but
Okay.
not comprehensively. Todd?
So, I mean, I think picking up on what Praveen said, I think definitely educating the public about what's at stake with judges. You know, it's not necessarily getting ideological, but, you know, I think certainly after the African American community, the polling shows that our community, we feel under siege by this administration. No particular issue, just under siege. And the Supreme Court, SCOTUS, is of utmost importance to that community. How to channel that into the larger community to understand how important SCOTUS is long-term for everything. I think it was a kernel of it with the Kavanaugh nomination, but I think sort of taking that to the next level without necessarily politicizing the court, but understanding how important the courts are is key. I think internally, we have to have senators who care about process, who care about fairness, who care about pushing back on sort of the naked grab for power, to do what they can to take back the tools they need to do advice and consent. So I think about Cory Booker and Kamala Harris and others putting up a big fight in the Senate Judiciary Committee to make sure their voices were heard regarding documents being held, regarding documents not being released in the Kavanaugh hearing, using every procedural tool in their hands to create a process where they can actually get information they need to actually do advice and consent. Very wonky, but I think a lot of times senators want to be very stoic and very collegial. Obviously, not everyone wants to be collegial, so they need to actually use the tools they have at their hands to get what they need.
Okay, why don't we do some questions from the audience if you've got any? I think there, as everyone knows, there are these mics over here, and just head to them and ask any questions that you might have. Oh, no questions. Yeah, okay.
Hi, so my question is about kind of two competing interests that we have. So we want to, on one hand, raise the alarm when radical nominees like Jeff Mateer, Brett Talley are being nominated in order to prevent them from reaching the bench. But we also have an interest in, having public attention towards the courts, and that requires, to some degree, the public thinking that the courts are legitimate or that they're not hopeless, at least. So my question is about kind of advocacy strategies in that realm, like how do we both advocate effectively against radical nominees, but also, preserve some semblance of judicial legitimacy or public faith in the judiciary?
I mean, I think the way we've advocated for this, again, we're the ones that brought you the rule of law, is to really talk about it in those terms, right? So, we don't talk about ideology. We don't talk about whether, how people feel about things. Look at their record. And I think there are certain things you can agree on. Jesse Helms, not a great civil rights advocate, not someone who believes in the legitimacy of all human beings. If you are going to go work for him, at the very least, you need to have questions asked of you regarding your role. That wasn't what happened with Tom Farr. He denied involvement. The Senate voted him out. Those are questions that we want our stakeholders to ask the Senate and to have them come back for another hearing. Those kinds of questions, those kinds of advocacy points I think are legitimate. Whether or not Brett Oldham, whether the nominee Oldham, who's now on the Fifth Circuit, says Brown was rightly decided, I think that's a legitimate concern to have regarding that person. So there's certain, I think, lines in the sand or lines that you really can't cross in terms of if you're going to be on the bench. Others think it may be the number of trials you've had. Others think it's some subjective temperament thing. We think it's that, plus whether or not you think Brown was rightly decided, whether or not Marbury versus Madison was okay. There's certain grounding things, rule of law things that I think are legitimate points of inquiry.
And I would just say groups can get involved in making sure that rules around state courts, where most people interact with state courts. That's what their experience is. And there's poor public confidence in state courts. And so our organization, Lambda Legal, in addition to fighting all of these nominees, was an amicus brief in Williams-Yulee to try to prevent, judges accepting money from, campaign finance decision to protect state courts. And so I would like to see, some reforms in these areas, making sure that trans folks have, protections in court rules. These can contribute to better judges, more fairness in the system, better confidence, while at the same time we can draw the line on some really bad people.
I think there's a couple of ways you can address this. One, I think we have to all acknowledge that, putting aside the fact that we're here on a panel talking about judicial nominees, and that was the prior panel too, and that's why we're having this conversation, the rule of law writ large in this country is under severe threat, and it is under attack. constantly. We have a leader at the top of the administration who attacks the Justice Department and the FBI on a regular basis and with venom. And we have elected leaders in the House and the Senate who won't stand up for that. Democrats and Republicans alike. Instead, they get lost in partisanship and attacking each other instead of uniting against threats to our nation from the outside, including from Russia. Can't seem to find a path forward on that effort in the House. It's pathetic, and it speaks poorly of our elected leaders, both Republican and Democrat alike. So we can spend a lot of time talking about nominees and judges, and that's what we're here to talk about. But the reality is the threat to the rule of law is much broader and much more concerning, and one that we as a nation need to come together and address. One thing I think that would be helpful is when we have groups of both ideologies, right, where we identify judges who are qualified and who are capable, and who, while they may have a judicial philosophy we don't agree with, we can nonetheless find a way forward to support. That will allow us to get back to a better place. And so, for example, you take Antonin Scalia and Ruth Bader Ginsburg, both clearly people with judicial ideologies that the other side won't necessarily agree with. They were both almost unanimously confirmed by the U.S. Senate. We have completely lost that concept, right? And that is partly driven by outside groups that can't find a path forward to supporting highly qualified, capable, although perhaps nominees might disagree with, support them. Instead, there's a complete view of you must resist all of them and support none, right? That's true on both sides. And it's a problem that if we're going to get past as folks on the outside, that is one thing I think we've got to do. And we've also got to unite across partisan lines to address the very real threat on the rule of law, both from people within our own executive branch, but also from the outside, from outside organizations like Russia and outside countries like Russia, which we are not effectively doing because we can't get past our own partisanship. And that's a real problem.
Any thoughts, sir?
Yeah, I'm not sure I have thoughts on this, but the rule of law thing makes me come back to a question that I think we haven't touched upon that you asked, Victoria, about sort of the separation of powers bucket. I think the rule of law, right, is a conversation between three branches of government, and one of the things I've begun to become really concerned about is we have 6 justices on the Supreme Court whose largest chunk of their professional lives had been formed by service to the executive branch, right? You have, Kavanaugh, Gorsuch, Roberts, Alito, Thomas, and Kagan, who really have the substantial executive branch. And you really only have Breyer, who had a congressional stint.
Kagan too?
And Kagan had a small stint, and then Thomas had 2 years in the beginning where he worked for Danforth. But
Right.
the majority of their sort of what you think of as formative has been advocating for a branch that's now involved in these disputes. And the rule of law, ensures, is only ensured when you have people willing to stick up in these interbranch disputes. And I'm concerned about the sort of perspectives currently that are informing people's.
Yeah, it definitely shows that they're kind of their institutional contempt for Congress.
Yeah, or at
Yeah.
least the institutional sympathies.
Right,
Like,
exactly,
Exactly.
Yeah. Any other questions? Oh,
Do you think the court was better in terms of composition when you look at the Warren Court, where you didn't have a career path to the bench, Supreme Court bench, that you have now? I mean, the governor of California, a labor lawyer organizer, an SEC commissioner, a former Ku Klux Klansman. I mean, Hugo Black had been a Klansman when he ran for state senate in Alabama. Could you imagine a nominee today before the Senate Judiciary Committee who, I was a Klansman, his picture me in the hood. I mean, it just, you think that it worked better than, because if you were to predict in 1948 that the Supreme Court would rule that it did in Brown with those people, you would have said no way. But now we're getting people who, at 40, you want to know what they're going to do for the rest of their lives. And that's kind of scary.
yeah.
So do you think it was better then or now? All 40.
Well, you
Sorry.
would think, I think you would think, right? You would think that a more professionalized judiciary, on the Supreme Court in particular, and a judiciary that had spent more time.
Not require you to be a lawyer.
I understand, but what I'm saying is, you would think though that having them more professionalized, having been away from politics for longer, right? Even these judges that you mentioned, they'd all been on the bench for more time than they'd been in the executive or legislative branches, and yet it's odd because you would think they would be more likely to be more moderate, more whatever, right? But it seems to be the case that perhaps not, and I don't know how to explain that.
Okay, we have one last question from Wendy, and then we're going to wrap it up.
This one might be long, so I'll be, we're talking about the role of the Senate in advice and consent, but part of what they're doing is questioning the nominees. The nominees, now we have a recent tradition of not answering really any questions about ideology that would reflect any direction of the judge's thinking. So do you think that that's a good thing or a bad thing? Should that be rethought? Is that correct for judicial independence? And what happens when a nominee, I mean, if we'll just comment on the kerfuffle around Justice Kavanaugh's partisan-leaning statements, and what does that mean also in the same vein?
Well, I think it's unfortunate that they've sort of conflated this idea that you can't talk about a case or an issue that might come before them with long-standing, well-established precedent. I'll just, say that. And I think it's unfortunate, disingenuous, and quite frankly, within the case of Brown, a dog whistle to others who frankly might want to bring a challenge to the underpinnings of Brown, that years from now, 20 or 30 years from now, when I'm on the bench, things will be good. So I think it's unfortunate. I think it provides an opportunity for a dog whistle. I think it provides an opportunity to sort of skate by. I think the Senate could do a better job following up instead of just letting them say things like, now they're saying it's well-established precedent. Well, precedent can be overturned. And so I think we need to do a better job holding their feet to the fire. In terms of, Kavanaugh's performance, I think I said it before, I think it reflected obviously to us issues around credibility that just were already there. There was nothing new with that performance. I think that it was something that I think signaled to the rest of the world, those who are concerned about impartiality and integrity, that the court might be undermined by that performance. And I think that people like Nina Totenberg, other sort of establishment thinking folks had that concern, and I still share it. That this process, how it happened, the lack of fairness in it, will ultimately, and we are even talking about whether or not there should have been a process, because from our perspective, given the cloud over this administration, there should not have been a process. But I think all of that goes to undermining potentially the legitimacy of the court, and we should all be concerned about that.
So I know we've exceeded our time, and I want to thank the NYU Journal of Legislation and Public Policy, Brennan Center for Justice, and the NYU Law and Government Society for putting this together. I think it was great. Really appreciate everyone coming, and we'll be around to, I think, probably to talk to anyone who's got individual questions for a little bit longer, although some people have got to hop on trains. But thanks everyone for coming.
Thank you.
Thank you.
Thanks.